It's unfortunate that our kids have to do drills in school to protect themselves.
Yeah, if we could stay away from current events.
Fair enough.
Go ahead.
Point being is, we're fortunate enough to be able to call for help when we're scared. Nathan Woodyard did not have that option. When he's assigned the call, he's required to respond. Who do they call when they need help? But here's the thing. Despite 70, 80% of Mr. Slot-Howard's arguments and closing arguments being specifically regarding that encounter, there's not one person claiming that that part of the encounter is what killed Elijah McClain. It's simply not an issue in this case. In fact, you even just saw, not one person has said that the carotid hold itself should not have even been used. Nathan heard, and you heard on the body cams, that Officer Redema had said, he just grabbed your gun, dude. And if you watch the body cams in terms of how that all came out, it wasn't even mentioned in his closing argument. You watch the sequence of events. Yes, in isolation, Mr. McClain's statement of, I intend to take my power back, should not raise that much of alarm. But when you combine it with, I intend to take my power back, and he jerks forward because Officer Redema pulled him without Mr. Woodyard's knowledge, and then followed by a split second later of, he just grabbed your gun, dude. That's the context you need to be judging it. He just grabbed your gun, not reached, not tried to get, not touched. He just grabbed it. Now, they have an opportunity to come back up for about 21 minutes, from what I've heard, to argue to you again. They get to respond to my arguments. And they may want to engage in an argument about whether Elijah McClain actually grabbed the gun. That's not something I care to engage in. That's not at issue. All that matters is that Nathan heard it. And he didn't know Elijah. He didn't know what he's like. All he knows is that his fellow officer just told him that a gun was grabbed. And not one person was willing to take that witness stand and say that the carotid hold was inappropriate in that situation. After the carotid, Nathan Woodyard walked away. Now, this timeline reflects hours of my life trying to piece together all the body cams. Because as you've heard, there's multiple body cams, as you've seen. And as you've seen, very unhelpfully, all the timestamps on the body cams are off. They don't sync up with each other. But these times are all synced to Nathan Woodyard's body cam. His camera gets knocked off and is recording, and you can match up the conversations from the other body cams to Nathan's. And this timeline reflects just how little this case has been about Nathan Woodyard being present. This entire case has been about these events here. Nearly every body camera that they played has been about this incident here. Now, they knew he walked away. You heard that they've had access to these body cameras for years. You've heard that they've spoken to now retired Sergeant Nunez years ago. They know that she ordered him away. And instead of telling you this, Instead of being transparent and showing you all the evidence and letting you make an informed decision, they start off beginning of this trial and even today saying that Nathan abandoned Mr. McClain. And then you saw them put up protocols. You saw them with Deputy Chief Stephen Redford bringing in the protocols. They chose not to bring you protocols that told you that Nathan had no choice but to leave because he was ordered to leave. They chose not to show you the protocols that says that when a sergeant is there, the highest ranking officer, they make the calls. They're the best to direct personnel during an emergency call. And you can see that the sergeants arrive pretty early in time. They take control within 3 minutes of when Mr. Woodyard exits his car. But even though Sergeant Nunez ordered Mr. Woodyard away, they first tried arguing to you, well, even if that's the case, he was still close enough, he was close around to hear everything that was going on. They felt comfortable enough to argue this to you without any evidence. They need you to think that he's close enough to hear fire when fire makes a decision on ketamine. Because as you can see, fire arrives on the scene when Nathan is away. Within 2 minutes of arriving, fire then decides to give 500 milligrams of ketamine. When the government decides that they need to blame someone, government decides that they need someone to take the fall, just shift public scrutiny from them to one individual. They don't stop. They don't stop regardless of what they see. Instead, they continue on. They shift their arguments and they try not to provide you the stuff they don't want you to see. Because the government doesn't stop, because they know that Nathan did not make any decisions on the ketamine, because they know that Nathan did not even talk to fire to try to induce them to get ketamine. They now ask you to try to convict Nathan based on the actions of others, because they can't get him on anything he did. Without the ketamine, Elijah McClain would still be alive. Mr. Woodyard did not inject him with ketamine, but the government doesn't stop. Therefore, you have this complicity instruction, both of them, jury instructions 9 and 10. Now, complicity is a way to convict a person of a crime for someone else's actions, but it's very picky. It's very specific. Otherwise, we'd all be in trouble for a whole lot of things. Key things you need to know that is that complicity requires Nathan to have a desire or purpose to aid, abet, advise, or encourage the other person to kill Elijah McClain. And the other thing,
It does.
to cause the death of Elijah McClain.
Still the state's law.
Actually, it does.
It does. It's encourages the other person to engage in reckless or criminally negligent conduct.
Thank you. And that they actually do that. But also, on number 4, it requires the government prove that Nathan was aware. If he does not know that fire is going to overdose Elijah McClain without conducting a proper assessment. And he's not guilty of complicity. Each of these elements must be proven to you. Mr. Woodyard simply had no way of knowing that fire was going to stand around and neglect their duties and just simply decide to inject Elijah McClain with 500 milligrams. This is the timeline of fire. And as you can see, they arrive, they make the decision all before Mr. McClain comes, or Mr. Woodyard comes back to the scene. You have the body camera footage of all the officers surrounding the paramedics Cooper and Jacuniak. They show up, they stand there. Suddenly, in a minute and a half, simply say, okay, well, once the ambulance gets here, we're going to go ahead and give them ketamine. No police officer suggests this to them. Now, after they say that, you do hear officers Rodema and Rosenblatt say, perfect, dude, perfect. That's only after Paramedic Cooper says we're going to give him ketamine. If I had a crystal ball that looks forward or backwards, one could bet that's what they want to argue on how officers Rodema and Rosenblatt tried to aid, abet, advise, or encourage the paramedics to follow through the ketamine. But they can't do that with Nathan Woodyard because he wasn't there. Now, as the days progressed through trial, their arguments progressed. Their arguments shifted. You may have heard them begin a new argument. That Nathan never told the paramedics that Mr. McClain said, I can't breathe. And if you look at the body cams and you focus in on this portion of time, looking back, we talked about this as a whole, about 19 seconds. If you shift it down to the initial 5 minutes, you can see when Elijah McClain complains about being unable to breathe. You can hear it on the body cams. And you heard Mr. Woodyard say, took the mask off, and we put him in a recovery position. And you can actually hear it on the body cams with the handcuffs being put on. I think Mr. Slaughauer mentioned that. You remember they're taught prone control, put them on their stomachs when you put on the handcuffs, and then you put them in the recovery position. The handcuffs go on, then you hear recovery position. And after that, Mr. McClain never complains to Nathan Woodyard about being unable to breathe. He does say it one more time, but that was when Nathan Woodyard was not present. So from Nathan Woodyard's perspective, he thought he addressed it. From Nathan's perspective, there was 8 to 10 officers around. There's always going to be a set of eyes on Mr. McClain. And from his perspective, he thought those set of eyes would be there to take care of Mr. McClain if any issues arose or persisted. I'm going to play a video, and the sound is intentionally off so I can talk through it. This is Exhibit 192, Officer Dunson's camera. And this talks about this period of time when Nathan walks away. Again, they told you, oh, well, he's close enough to hear. He's close enough to hear everything that's going on. But you can see just where he comes from. You can see him behind that car by 225, come up and walk to the scene. You may not have seen these body cams that often. You may not have seen these body cams before trial, but they did. And they saw it before they tried to argue to you that he could hear everything that was going on. You also heard Sergeant Nunez testify and tell you that she ordered Nathan to follow her. And you can hear that in the body cameras. This isn't something that she made up later on. And you also heard that they spoke to Sergeant Nunez before this trial, years before. And they chose not to call a single sergeant, not to bring in anyone, any high-ranking officer that was on there that night. We had to call because they wanted to argue to you that Nathan walking away is him abandoning Elijah McClain, unless you guys learn differently. What they fail to show you is that the paramedics would have done anything differently. Have they shown you any evidence that if someone was to tell the paramedics, hey, so he was complaining about breathing, but he stopped now? Paramedics say, okay, well, maybe we don't give him 500 milligrams of ketamine. Maybe we do an assessment. This is all speculation. This is all them wanting you to guess because it doesn't matter. Just give them a conviction. That's what this case is about for them. I want to remind you that they carry the burden in this case. They carry the entire burden. What happens if we were just playing pinochle, like Judge Warner suggested? What does this case look like? This isn't a case where they want to show you all the evidence. And to be clear, under the jury instructions, nothing says that they do have to show you all the evidence. But you get insight into what they want. You get insight into whether they want this to be a transparent proceeding of here's everything. You make the decision. Or only pay attention to what we want you to see. Don't look at the other stuff. Don't worry about those things. Some of you even warned us about this in jury selection. Some of you talked about
That's not evidence in front of argument.
All right, the court allows counsel to engage in rhetorical flair. So these are closing arguments, they're not evidence.
Okay, Judge, thank you. So some of you talked about that. That on social media, you can't really trust everything you see because with body cams, sometimes they post it very manipulatively. That they don't show you the whole thing, that they stop it seconds before. The type of case that the government chose to present you is a type where we had to stand up and say, Officer Alicia Ward, I want to talk to you about that video that the government just played. Let's just play it 3 more seconds. They didn't show you that part, did they? Sergeant Nunez, you were asked a bunch of questions about your past sworn statements. Let's just read a little bit more in that transcript and see what you're actually talking about. Were you actually talking about that you could hear him when you could hear Mr. McClain when you were talking with Nathan? Or were you specifically asked, are you referring to when you were with Mr. Woodyard or when you're standing next to Sergeant Dale Leonard? Oh no, all that was when I was standing next to Sergeant Leonard. This is the type of case where we've heard from every single one of their doctors who say that the overdose of the ketamine is what killed Mr. McClain. and they don't show you the ketamine training slide from Aurora Fight. Now, those timelines I was talking about, you certainly don't have to do this. But having suffered through this and having years of my life dedicated to this, as a suggestion, it's very difficult to ascertain the exact sequence of what happens because you have multiple officers walking around and multiple different perspectives. And for you to sit and look through all 15 body cams, 20 body cams, estimation, and try to figure out when is what and when did this one pick up, when did this one stop, it's going to drive you crazy. So as a suggestion, you certainly don't have to do this. This is one way of trying to piece together from start to finish. And you can check it. And you can check me on that because I intentionally overlap conversations where you can pick it up in the next body cam. Now, I want to talk about Dr. Terashenko. They called 3 doctors who have been involved in this case since 2021. Here's the next part of that. Part 2. They called 3 doctors who have been involved in this case since 2021. We had to call Dr. Nadia Terashenko. She told you that Mr. McClain suffered a cardiac arrest right after the ketamine.
She misstates the evidence.
All right, I'll simply instruct the jury that you're to use your collective memory and the exhibits to determine what was said.
Question. What is concerning after this injection of ketamine? Well, he's lost muscle tone. What are some red flags? I see an agonal breath. What does that agonal breath mean? It means that he's having trouble breathing, and it likely means that he suffered a cardiac arrest. Well, what does the cardiac arrest mean? His heart stopped. He stopped breathing. Since 2021, keep in mind, we had to call her. Now, once we called her, Mr. Slaughter had no questions for her. Isn't that interesting? Because she just took the stand and she told you all that this is Paramedic Cooper and Paramedic Chikuniak's fault. They didn't want you to hear that. Now, they've asked every other expert. Should the police be telling you about any, be telling the paramedics about any breathing issues? Didn't ask the one person that was qualified in paramedic training, roles, and protocols. Because they don't want the answer. But you know the answer. You remember the exchange I had with Dr. Terashenko. The point where we're arguing. One last question, Judge. This will be the last one about it.
Objection and proper objections and evidence that's been excluded. It actually was an objection.
All right, move on, please.
And I was allowed to ask that question. And she says, nope. Conversations with police, that's historical. They're not medically trained. They don't know. That's like anyone else on scene that just says, hey, look, this is what I saw. You don't take that as gospel. You do your own assessment. This is basic education. Now, They want to now embrace her testimony and say, yeah, we knew this all along. That's still part of our theory of prosecution, but we just didn't want you to know it. We don't want to call her for you. But no, it doesn't hurt the case at all because it kind of fits, right? And you really need to ask yourself at this point, why? If they have the evidence, if they have the confidence in the case, why not be transparent? When someone dies, there should be an inquiry. When someone dies, there should be transparency. But don't think for 1 second that these proceedings were all about transparency.
10 minutes.
Thank you, Your Honor. This is about getting a conviction, any conviction at all costs, truth be damned. Whether Mr. Woodyard was present or not, it does not matter to them. The government does not stop when they need a conviction. They talked about Sergeant Smith. And they talked about, well, you know, he got a little squirrely when we started talking close to the issues here. Keep in mind, that was their expert. Keep in mind, Sergeant Smith met with them multiple times in preparation for this case. They weren't caught by surprise by anything he said on the stand. They just weren't happy with it. You even saw Mr. Slaughter put up the slide on the carotid hold. And you remember Sergeant Smith saying, what we're telling them is don't just apply the carotid over and over and over and over again. You heard them bring up Grant Heineman, who told you in the practical, we teach them to do it multiple times. You first do the carotid, and then we have them try to put on the handcuffs. And then we tell the actor, now fight. And that point is to get the officer to see if they can get back into the chancery hole, back into the carotid hole, and apply it again. What is that? That's twice. But why does that even matter? Why does that matter in this case? Because they can't prove that Nathan was even aware that there's 2 carotids. They can't even prove that 2 carotids were applied. It's perfectly appropriate for an officer, if they can't get in the position for the carotid, to not apply it, to abandon it. There's 1 carotid that was applied, not 2. They want you to think there's 2. And you heard, as I mentioned, they get a chance to come back up. I don't. You've gotten a chance to see how they want to present their case to you. And you've heard that our arguments are not evidence. You're to rely on your own collective memory. I don't have the ability to come back up here and say, well, wait a second, play that body cam 2 more seconds. Or wait a second, that's not exactly what they said, is it? All I can do is object. I can't stop them from selecting what they want to present. And when I object, you'll likely hear that you have to rely on your own memory. So I urge you to rely on your own memories. Because they're going to get up here and it'll become obvious to you in terms of their case, on how they want to present their case based on their arguments. They'll likely tell you, even if you're not willing to convict Mr. Woodyard on a crime manslaughter, you can still get him on something else. You can still convict him on criminally negligent homicide because it doesn't matter to them what you convict Mr. Woodyard on. Just get him a conviction is what they're going to ask you. Something, anything. We can only hope that the truth matters to you. We can only hope that transparency matters to you. So Nathan took the stand. It was important for you to hear from him. That's Nathan Woodyard. He's the guy that makes sure that everyone's body cam is on to record the encounters. It hurts their theory that he's the guy that wants to make sure that his interaction with Elijah McClain is recorded from multiple people. The person you saw on the stand is the same person you saw in Officer Dunson's photo. That was hard to watch. It's hard to watch for two reasons. One, you hear Elijah on the ground, and that's absolutely heartbreaking. And the second thing that's hard to watch, two officers, Officer Edema and Rosenblatt, as this standing back there, shook. They're able to have a casual conversation as if nothing happened, as if no big deal, that they're just involved in a violent encounter just seconds ago. But that's not Nathan. Nathan's standing there. He can't speak. He's shook. This isn't what he wanted. And Sergeant Nunez sees that. And that, to them, is abandoning Elijah McClain. This is what they don't want you to see. They had this. $500 milligrams. Everyone gets 500 milligrams is not good practice. You need to monitor if you use ketamine, those medical devices that they're trained on. This is an example of why our jury system is so important. Beginning of this trial, Judge Warner talked to you about how our jury system was implemented essentially because it was a revolt from King George's attempt to banish the jury system. When our forefathers created our constitutional principles, they ensured those constitutional principles are protected by the community.
I'll allow it.
You are the ones who give meaning to our constitutional principles. When we talk about those principles through those double doors, they mean something different than in here. Because you get to decide whether we make exceptions for individuals of, this isn't the case to hold them to their burden. This isn't the case to find proof beyond a reasonable doubt. In these doors, within these walls, only then do we know how strong these constitutional principles really are.
Couple minutes.
Thank you, Judge. This is Nathan Woodyard. I know that now. When I walked away, I thought he was in the recovery position. There were other officers with him. I thought he was safe. Trust that they take care of him? Did they? No. I know that now. This is such an important job for you all. I'm wrapping up, Judge. Because this is a job. When you walked in through those double doors, you're no longer a doctor. You're no longer a plumber or an operations manager. You are a juror. And you went through an extensive job interview that first day where the judge, the government, Mr. Sawhauer, and Ms. Downing all asked you a bunch of questions. And we all decided that you were best qualified for this case. You took on the title juror. And in here, in these walls, you know that anger doesn't replace evidence. You know that anger doesn't help them connect the dots that they're missing. Nathan Woodyard is here because he trusted people to do their jobs. And they didn't. Elijah McClain died. Now we're trusting you to do your job. Please go back there. Evaluate the evidence. All the evidence. Even the ones they didn't want you to see. You know he did not kill this man. You know the only reason why he walked away. Because he needed a few minutes to collect himself. And you know you're the only ones that can set him free.
Mr. Slaughter.
He knows that only now? This defendant knew then. He's the one who started all of this, who escalated it every step of the way, who knew from his training about all of the risks and ignored them. The defendant, sort of like we were talking about in jury selection, knocked the proverbial kid into the lake. That's what he did to Elijah McClain. He grabbed him, he escalated the use of force, and he used the carotid on him. Caused hypoxia, aspiration, and acidosis. He knocked him into the proverbial lake and then walked away without doing what he was trained to do. That's why he abandoned Elijah McClain, not because of what he was off doing, but because of what he didn't do. He didn't tell his sergeant that Elijah McClain couldn't breathe. He didn't tell his sergeant that Elijah McClain had vomited into his mask. That's the abandonment, not who he's talking to or where he's standing. He knocks him into the proverbial lake, leaves without throwing him a life vest. And then when he comes back, Elijah McClain is literally face pinned down on the ground, stomach on the ground, shoulders flat against the grass, prone. The metaphorical equivalent here of being face down in that lake and drowning. And that's the situation Elijah McClain is in when the defendant comes back. And he knows it. He can see him face down, drowning in his own vomit there. The same person who he knocked into this lake to begin with. And his excuse is, oh, well, there's a lifeguard over there. Maybe they should do something. He is trained that it's his responsibility. It's common sense that it's his responsibility. It is what any reasonable person would do. If you create a danger, if you create a deadly situation and you know how deadly it is, and you are trained specifically how to stop it, and then somebody asks you, in this case, Officer Rudima, it's like, should we keep doing this and then move him over to the gurney? Yeah, let me get my gloves to help. The metaphorical equivalent of standing there on the dock at the side of the lake, and somebody saying, oh, we're gonna leave him drowning there in the lake for a couple more minutes, and then we're gonna pick him up and we're gonna move him onto the dock. Yeah, let me get my gloves to help with that. That is why Elijah McClain is dead. The defendant caused it. This entire last 70 minutes isn't about the evidence in this case. Trying to throw up this smoke screen like, well, we called this witness and the prosecution called this other witness, so there must be something weird going on here. That's not what you make your determination off of, not who called what witness. Based off the evidence, what every witness who took this stand and told you under oath happened, what they saw, what the evidence means. That's what you make your decision on. And that is essentially uncontested. Did you even hear the defense argue that Mr. Woodyard wasn't reckless in grabbing Elijah McClain? That it wasn't the wrong thing to do? That it didn't violate his training? They even argue that he didn't keep escalating the situation, making it more and more dangerous? They even argue that the carotid didn't cause hypoxia? That it wasn't the only event before ketamine that would explain Elijah's medical condition? It is the only event. It's the only explanation, is that the defendant caused all of this. Now, oh, sorry, I'm sorry. The defendant caused all of this, not Elijah McClain. This quote from Mr. Woodyard seemed innocuous at the time, but it's chilling. To him, to the defendant, this was just police work. This was something he would expect. He's telling you that he expects to grab Elijah McClain, that this is just police work, to turn him around, to threaten him, change the situation. To him, that's what it means to do police work. That is expected behavior. The badge, this defense that's in instruction 15, only goes so far. It only protects this defendant from reasonable and appropriate uses of force. Because, ladies and gentlemen of the jury, make no mistake, if you strip the badge off of these folks, this is just a group of people beating somebody up. The only way that they are legally allowed to do the things they did to Elijah McClain is if it fits under this instruction 15. And every single part of that requires that the use of force, every use of force, needs to be reasonable and appropriate. Otherwise, it's just the same as a gang of folks beating somebody up. Now, the defense during their closing argument essentially gave up on trying to defend Mr. Woodyard's actions. I mean, nobody's arguing that what he did was reasonable anymore. Nobody's arguing that it was within policy. It is crystal clear it was not.
All right. The court, again, will allow counsel to engage in some rhetorical flair.
Really, the only thing they're arguing to you is, hey, aren't the paramedics worse? But that's not what the law says. The law says that intervening cause, that it's the paramedics' fault, is only a legal defense if these three things are all true. That somebody else's actions, and here they're saying the paramedics, aren't foreseeable. Well, what do you mean they're not foreseeable? Mr. Woodyard is right there, before they give the ketamine, after they give the ketamine, while he's being pinned on the ground. Of course they're foreseeable. He's there. And it has to be one with which he didn't participate. Well, he created the entire situation that got them there. Why are the paramedics administering ketamine? Because nobody told them Elijah McClain can't breathe. The defendant didn't tell his sergeant that. He didn't tell the paramedics that. They got bad information. And then he's participating while they're there. Mr. Redeema says, hey, Woody Rosie, in a minute, we're gonna move him off this prone position here on the gurney. He says, yeah, puts on his gloves to help. And this last part, Dr. Buther and Dr. Mitchell explained to you that even though the ketamine is so deadly, it is the contribution of all these factors together. It's not just one thing. And when you go back in a little bit to deliberate, you can choose how you want to approach this issue. Select your foreperson, figure out how you want to proceed. Sometimes it's easy to pick the most gregarious person, but remember, your verdict has to be unanimous, whatever it is. So somebody who can listen well, actively listen, and build consensus might be a good leader. But then you have to decide how to approach discussing this. I'd recommend that you start by just talking about the facts. Talk about what was important from each of the witnesses. It's been 3 weeks. Some of you were taking really good notes. Some of you may remember some important facts. Some of you may remember other important facts. And talking through those witnesses will help you all understand what your view together of what happened is. But you're also going to have to talk about some issues. And based on what the defense said right there, I think these are some of the big ones that you may want to talk about. First is, what risks, what problems, what dangers did Mr. Woodyard create? Another one, medically, what's happening here? Why is Elijah McClain in such terrible shape before he gets the ketamine? And finally, what does the badge protect here? Is the defendant using reasonable and appropriate force? If he had used reasonable and appropriate force, Elijah McClain. No, he is. Now, you will have access to Elijah McClain's mask. And you're going to have this video. Snippet 178. You can listen to it. And you can piece together between what Mr. Woodyard said on the stand and that video exactly what happened. Because you'll hear the conversation and you can hear that horrible noise of Elijah McClain vomiting and aspirating. That and you hear the officers talking about flipping Mr. McClain to cuff him. They're putting him prone to cuff him behind his back. So Mr. McClain has vomited into his mask and is now being pinned down. You hear him groan. He says, I can't breathe. I can't breathe. I can't breathe. Over and over, muffled by the sound of that mask and the vomit with the aspiration deep down in his lungs. Then you hear the handcuffs go on. That's what Mr. Woodyard told you on the stand that he heard too. And he says, only after the handcuffs did the mask come off. Elijah McClain had that vomit-soaked mask clamped in front of his mouth for almost a full minute while he's gasping for air from the exertion of what the police are doing to him. Of course he aspirated. And of course, just like Dr. Buther said, it was a large volume aspiration. Look how much vomit is still in that mask 4 years later. Now, they showed you a quote from Dr. Buther about how ketamine was the primary active agent in Mr. McClain's death, but they left out the preceding couple of paragraphs. And they left out where he talks about why Mr. McClain would not be coughing if he had a large volume aspiration in that mask. Because if it's a large volume aspiration, it's not like sipping a little bit of water, where that water's sitting at the top of your throat, where you all know your throat's so sensitive. If it's a large volume aspiration, if that mask is clamped over his mouth for a full minute full of vomit, it goes way down deep into your lungs. And it's a different story. That's why Dr. Buther's opinion is so important. They talk to you about Dr. Terashenko, but she even says, yeah, what you tell the paramedics is important because it cues us where to focus our examination, our assessment. And here they're cued to the carotid. Nobody, the defendant especially, doesn't cue them in to the I can't breathe statements. So his escalations are creating all of these risks, both the risks of the paramedics doing the wrong thing and the medical risks to Elijah McClain. So why is his condition getting worse? There is only one explanation, and it's the carotid that the defendant hit. Nothing else happens until the ketamine. And Dr. Sina helps explain it. He says, you know what? I've never had an overdose death from ketamine where the levels are this low. That blue chart is the therapeutic level of ketamine in somebody's blood. That's what matters. How much is in your blood? How much is injected? And he also says he needs somebody like Dr. Buther in order to assess a living person's breathing. And he even explains to you why he didn't pay attention to Dr. Buther. He conceded to you that he's egotistical. And it's sometimes hard to admit that other people know more than you do. And that person in this case is very much Dr. Buther. Internationally renowned respiratory specialist, deals with aspiration issues all the time, and specifically focused on whether or not Mr. McClain aspirated into his mask and whether it was a large volume aspiration. He's the only person who did the work to figure that out. He's the only person really qualified to offer that opinion. And Dr. Sina just ignored it. Doesn't even remember his conclusions. And Dr. Buther says that it's these things together. And that's just so obvious, right? If you have somebody in the terrible shape that Elijah McClain is in, prior to the injection of a sedative like ketamine, of course it's going to be more dangerous. These doctors can explain the mechanism to you, this acidosis, this aspiration, this hypoxia. But you all could have watched this video yourselves and known that this is very dangerous. The defendant knew it because it's so obvious. Why is Elijah McClain being pinned down prone, getting this chemical sedative? The defendant told you when I was cross-examining him, he said that he was aware that fire comes and they give chemical sedatives because they think somebody's combative. That's exactly the story that he knows is being related when they call them out for the use of the carotid, that they were fighting with him and he went for a gun. We had to do the carotid. He knows this is coming and he's there when it happens. Dr. Arnauld doesn't really add a lot to this case, but he did tell you that even though he didn't watch the video before filling out his report, but if vomiting and aspiration occurs, that would be an independent problem. And that's the same thing that Dr. Sina says. These guys aren't saying that anything about what Dr. Mitchell and Dr. Buther are saying is wrong. They're just saying we didn't do the work. We don't know. They also didn't have the benefit of Mr. Woodyard's own testimony. explaining to you why we know that that mask was on for a whole minute full of vomit. That's all the proof you need to know that Elijah McClain's aspirating that vomit. And you see the effects of it over the course of the next few minutes when Elijah McClain's condition keeps getting worse.
You have a couple minutes.
Thank you. The defendant himself told you that just because his sergeant shows up, that doesn't relieve him of responsibility. Everybody has to follow their own training and do the right thing. And he also told you, and explained a lot of his actions, that he knew on the scene that he was in trouble. Because Sergeant Nunez told him that major crimes comes out when the carotid is used. And what's the very first thing he does once he finds that out and comes back near Elijah McClain? Is it to check on Elijah McClain, who's face down in this proverbial lake and needs help? The person that he knocked into this proverbial lake? No. This is the person the defense just told you is here about transparency. The guy who hears that he might be in trouble, his major crimes he might be investigating, and his very first action is to go grab Mr. Rosenblatt, who's been with him from the beginning, and pull him outside of the range of the body-worn cameras. And what did he tell you under oath was the reason for that? They wanted to talk about what reports they were going to write later. When I asked him the obvious question, you went and you talked about what happened, didn't you? That I don't remember doing that. That testimony is not credible. But neither was his testimony about what he heard from Mr. McClain. On direct examination and cross-examination, he said over and over again, yeah, I could hear Elijah McClain say, I can't breathe. But then on redirect, he can't keep his story straight. And he says, well, I can hear it today, clearly, in the bottom right corner, but I don't remember in the moment hearing. He was obviously very emotionally affected by these events. But he's also just very clearly telling you all what he thinks you need to hear. Because his actions were clearly reckless. And even in the best case description, what the defense is saying here, that maybe he didn't know all of the facts. Well, that's what criminal negligence means. Through a gross deviation from the standard of care. So by ignoring all of his training, everything that he knew were the risks, he fails to perceive a risk rather than consciously disregarding that risk. He caused this.
About to wrap up.
He caused Elijah McClain's death these 4 ways. If he doesn't change the situation, none of this ever happens. If he's using reasonable and appropriate force, the only kind he's legally allowed to use, this doesn't happen. The injuries that he caused that made Elijah McClain so vulnerable to the ketamine, all from the carotid, all from his actions. He makes the decision, knowing about the mask and the complaints that he can't breathe, that this isn't a medical emergency, and there's no need to tell the paramedics, which leads them on the wrong path. So they go towards ketamine. Then finally at the end, they've got that plan to leave Elijah McClain prone while they give him ketamine. Says, yeah, it's not as close to that. Every phase, he's the reason that Elijah McClain is in more danger. He's guilty, being reckless, causing his death.
Are you ready? Do you and each of you solemnly swear or affirm under penalty of law that you will, to the utmost of your ability, keep the jury together in a private and convenient place? You will not permit any person to speak to them, nor speak to them yourself, unless by order of the court, except to ask them if they have agreed upon a verdict, and that when they have agreed, you will return with them into court. All right, when we selected a jury, we selected some alternates that in case somebody were to have a illness or a family emergency, the alternate juror would serve as one of the jurors. So I'll let you know at this time, we have the jurors in seats 13, 14, and 15. You are alternate jurors. What I'm going to do at this time is release the first 12 jurors in seats 1 through 12. I'm going to ask that you be back downstairs in the jury assembly room in 1 hour, so roughly 10 minutes after 1 o'clock. And we'll just bring you straight back into the jury room and you can begin your deliberations. For the jurors in seats 13, 14, and 15, I'm going to ask you to stay here for just a moment. I have some different matters I need to discuss with you. You're welcome to have a seat if you'd like, or you're welcome to stand if you'd like as well. Please be seated. All right. Well, due to the length of this trial, that it was a 3-week trial, as I mentioned to you early on, I can never predict exactly how long a trial is going to take because once the jurors begin their deliberations, there's no stopwatch. Now, hopefully, all 12 of them can continue with the deliberations. But there have been times that I'm aware of where at some point during the deliberations, one of the first 12 jurors has some sort of family emergency or illness. And within certain time constraints, what would happen then is I would call one of you back and say, we lost a juror, we need 12 jurors. But what I have to tell the other 11 that are remaining is forget everything that you've talked about in the jury room, and you have to start all over again with our new juror. Now, at a certain point, it's my belief that it's kind of impossible to forget about all the deliberations. But as I said, it's been a relatively long trial. So what I plan to do is this. I'm going to release the 3 of you, kind of. And let me explain what that means. My expectation, I don't know how long the jurors are going to deliberate, but should they go into Monday and it gets to be sometime in the afternoon on Monday, I kind of arbitrarily pick the time of 3 o'clock. I would feel uncomfortable sending one of you back with the other remaining 11 to continue the deliberations. So I'm going to ask that you remain available and perhaps share your cell phone number or whatever with one of my staff. And you can also let them know if we don't call you back, if you're curious about what happened and what the verdict was, my staff will share that with you. But at least until mid to late afternoon on Monday, I'm going to ask you, please, please don't form or express any opinions and discuss the case with your family and friends, and stay off the internet and avoid any press coverage. I guess I will hope for the best and anticipate that I won't see you folks again. And I hope that's the way things work out. And I think hopefully all of our jurors are able to reach a verdict. But that being said, I want to thank you for the time and attention. When they say it's jury service or jury duty, boy, is it. You've had to listen to some tough evidence in a tough and important case, and all of the cases that I consider them all important that come into this courtroom. So if I don't see you again, I'm going to thank you. I'll let my staff know to give you a call Monday afternoon, or if a verdict is reached beforehand, to release you from your service. With that, thank you for your close attention. And moreover, what I'll tell you is this: thank you for your patience. I always wish trials could start at 8:30 and go till 5 every day. But the practical reality is we have witnesses that have jobs who are out of state and all kinds of things. And I'm confident that the attorneys in this case worked really hard to get the case to you in a timely fashion, but there's just a lot of evidence in the case. So that's where we ended up. So if you'll share your numbers with my staff, I'll excuse you. And we will call you, A, if there's a verdict, B, if we need one of you back, or C, just to let you know you're released. So thank you so much. Have a good day. All right, the jurors stepped out. Anything folks need to put on the record? All right, thank you. If I expect my staff probably has your numbers already, but if not, if you could just write them down on a piece of paper on a sticky in case we have a question or something after lunch.